Thank you, Judge.
Mr. Devaney, well, welcome to our session today of the Kansas Court of Appeals. We are gathered for one case. My name is Catherine Gardner. I'll serve as the presiding judge. I'm happy to be here with Judge Tom Malone and Judge Angie Coble. And we thank counsel for your flexibility and pivoting to this format instead of meeting us in person in Wichita. We have your case set for 15 minutes. And so I'll call the case of 126891, Howard Ray Pruitt, appellant versus the state of Kansas. And I'll take appearances, please.
Go ahead.
May it please the court. Appellant, Mr. Pruitt appears through counsel Chris Joseph.
Thank you.
May it please the court. Counsel for the state of Kansas, the plaintiff, the appellee in this case, Darren Devaney.
And Mr. Devaney, were you on the briefs in this case?
I was not. My assistant, County Attorney Cheryl Pierce, was on the brief. I'll be appearing for arguments today.
Okay. And may I have your bar number then, please?
19587.
Very good. Okay. Appellant, you may proceed, and please let me know if you would like any rebuttal time.
Thank you, Judge. If you could give me, say, 3 minutes as a warning, that'd be great.
Okay, we'll do.
So I don't do a lot of 1507s, but this one, I mean, I probably had a dozen or so. This one really kind of rises to the top, in my view, as what constitutes the wow factor in things that happened and that did not happen at trial in terms of error and ineffective assistance. The first, and I'm just going to run through these as an overview and take questions as appropriate. The first is this Exhibit 40 that got into evidence, and it's Volume 3. I think everybody's seen it. Exhibit 40 has the location of Mr. Pruitt's phone. Dots 1, 2, 3, and 4 put him near the murder scene. And even worse, dots 6 and 7 put him out in the country by where Mr. Perry said that he found the gun. That Pruitt said, go get the gun here. It's like 20th Street out in the country. That is, I mean, incredibly damning evidence. He gets in front of the jury sees it, the jury hears testimony, the jury hears explanation about it. And then ultimately later, counsel moves to strike the exhibit. What exactly the judge struck is unclear to me. It sounds like he said Exhibit 40 will be struck. The state thinks that he struck the testimony too. In the end, it doesn't really matter, because at no point does anybody ask the judge, nor does the judge instruct the jury to disregard that evidence. And so no request for mistrial, no request for an instruction to say, jury, you can't consider that. They considered it. It was not, I mean, they weren't told not to consider it. And that is incredibly damning evidence. I mean, that's enough just to convict somebody. So what's left? If that's not grounds for reversal, the only way for it not to be grounds for a new trial is if the other evidence was just kind of overwhelming and it was not enough to constitute prejudice.
Right.
The other evidence comes in, and this ties into the second part of it, what the jury didn't know. And this is also shocking to me a little bit. The other evidence constitutes the testimony of Mr. Coe, the gentleman who was originally charged with murder, and only after being charged, taking a polygraph, again, not for the truth of the matter, but being told the results of it, suddenly says, I can identify who it was, the guy that was wearing a mask. I saw his eyes in the dark. I've only met him once or twice, but it was Howard Pruitt. So his testimony starts off a little bad, a little questionable. He then says, oh, by the way, I was going to buy that murder weapon from a guy named Billy Heisey. I didn't. Howard bought it. A little bit later, and this is where we get to that important constitutional harmless error standard. A little bit later in the trial, the jury gets to hear that this Billy Heisey guy told the detective, nope, that's right. I sold the murder weapon to Mr. Pruitt, not Mr. Coe. That's constitutional harmless error. And that is pretty important and devastating evidence as well. That was not struck. The objection wasn't contemporaneous. It came on the next question. The judge did not instruct. It was not asked to instruct the jury not to consider that. He sustained a subsequent objection. The jury was never told they couldn't consider that. The other two folks that could be overwhelming or could be something to set aside the prejudice are Mr. Ballinger and Mr. Perry. And on its face, what the Supreme Court would have looked at, just the record, their testimony is pretty bad. What the jury didn't hear, and this is where you get into ineffective assistance, is the stunning information that the police in the interrogation, you have this, it's attached, the transcript's attached, the exhibit's there. The police said, hey, starting with Mr. Ballinger, we know you drove him there. You won't get arrested if that's what happened. You didn't know what was happening. You just took him there and he did it. Oh, and by the way, here's a picture of the gun that we found fished out of this river. Tell me what happened. And they say, oh yeah. Ballinger says, oh yeah, exactly what you said I won't get in trouble for happened. I drove him there, or I went with him there. I didn't know he's going to do it. When he pulled that gun out, the picture you showed me, that gun, he pulled it out and he went off with it. The jury didn't hear that. I mean, that's, if it's coming down to credibility, you have to know that. And I can't wrap my mind around any kind of strategy. None was offered at the 1507 hearing as to why that was not brought in. In fact, it was brought up earlier in court in a motion to exclude their testimony as not as being coerced. So, like, counsel knew that. Mr. Perry has the same kind of scenario. Like, hey, here's the picture. We recovered the gun from the river. Here's where we found it. You're not going to get in trouble if, say, he told you to go get rid of it and throw it over that bridge. Lo and behold, he says, guess what happened? Exactly what you told me I won't get in trouble for. Oh, yes, and I'll describe the gun. Now,
so,
Mr.
counsel,
Yes.
I appreciate that there was some, that was really litigated, and the judge apparently found that that was not coerced testimony, correct, for the earlier hearing?
Correct.
And so was it not a valid subject, I presume, for cross-examination when they're testifying?
Should have been, yeah, absolutely. And counsel didn't bring it up. That's my point, is he was on notice. Counsel should have brought up the fact, I mean, what the statements weren't excluded, but he needs to inform the jury that, hey, police said, if you say this, you don't get in trouble. And showed him a picture of the gun. I mean, if you read the Kansas Supreme Court opinion, they talk about how many witnesses testified about the recovered gun and linked it to Pruitt as being the strong evidence. Yeah, I mean, without context, that's pretty strong evidence. They described the gun accurately. What they didn't know.
Didn't trial counsel cross-examine each of those witnesses about at least, and it's been a minute since I looked at those cross-examinations, but I know for sure at least Perry and Ballinger about their multiple discussions with police and about the police telling them, hey, you're not going to get in trouble if, didn't the police tell you you're not going to get in trouble if you say X, Y, Z? I mean, didn't counsel cross-examine them about the police statements? He
cross-examined them about repeated interviews, denying it initially, and then later coming forward at the last minute and saying, suddenly having memory. He did not cross-examine them about police saying, you will not get in trouble if you say this. We believe this to be happened. He did not cross-examine them about whether or not their description of the gun, which the jury found out was accurate, came after they showed him pictures of the gun. Those are the two flaws. And when you look at all that, I mean, that's the sum of the case. You have two tremendous errors, and you have the constitutional harmless error built into that because you have the confrontation clause problem with Billy. I mean, that alone is enough to do it. Mr. Coe says, I was going to buy that gun, but instead he sold the murder weapon to Pruitt. The objection comes too late. Mr. Heisey, with Detective Murphy says, Mr. Heisey told me he sold the gun to Pruitt, the murder weapon to Pruitt. That alone is a confrontation violation. The objection comes too late, never told to disregard, no curative effort. The state now has to prove that there's no chance that impacted the outcome of the trial, and there's no way you can do that. Then with this really damning Exhibit 40, which puts him right where Mr. Perry said he found the gun, that's damning. And you have to get beyond that by saying that there's no prejudice. I can't imagine how there's no prejudice from that.
Well, a lot of times we look at prejudice just as, obviously looking at what was admitted in evidence, what wasn't admitted in evidence, what should have been or shouldn't have been, according to your arguments. And, the trial court tried to do that here, and it looks like it found no prejudice, but you're saying that it relied on these things that were insufficiently queried into at trial. Is that correct?
So my argument is that the jury saw horribly prejudicial information, that there is prejudice because the jury didn't get to hear about the police tactics that led to these statements. Now, at the 1507 hearing, Judge Hart adopted the state's proposed findings of facts and conclusions of law. I just disagree with them. He just went on the record and said, I adopt them. I think they're wrong.
Well, the other stumbling block or piece of evidence here that we have is the Kansas Supreme Court ruling on direct appeal, where it says, I think unsolicited, says that there was truly overwhelming evidence against Mr. Pruitt in this case.
Correct. And I recognize that, and happen to have it ready, anticipating that question, Judge. So there was overwhelming evidence that whoever shot Little did so, and talks about first degree. There is strong evidence that the someone was the defendant. So the phrase they used was strong evidence. Now, that's the stumbling block. That is, they didn't know, much like the jury didn't know, that the strong evidence of Coe, Ballinger, and Perry was testimony accurately describing this gun in the hands of Mr. Pruitt only after the police just showed him the picture, and only after the police said, you won't get in trouble if this happens. Supreme Court didn't know that either. And on the record, sure, I don't disagree. On the record, without that additional information, the evidence is strong. They've got these three folks all saying these same and accurately describing this firearm. Makes sense. So you don't have to say the Supreme Court's wrong. You just have to say the evidence not presented to the jury, not presented to the Supreme Court, is where you find the prejudice.
And you're about at your 3-minute mark.
Okay, thank you.
Mm-hmm. Happily, you may proceed.
Thank you. Well, may it please the court. Addressing, I guess, in order that's already been laid out here, Exhibit 40 was before the jury. I don't really take issue with as far as the facts or as they've been presented, as far as how that went down at trial. But want to stress once again, we did so in the brief as well, that Exhibit 40 was stricken. The motion by defense counsel at the time was for the exhibit and testimony to be stricken by the court. And after some back and forth with counsel and the trial court, that's part of the transcript, Exhibit 40 was stricken. And as a part of striking the exhibit, did the court instruct the jury at that point you're to disregard it? I don't think there's a specific asked him to disregard Exhibit 40, but as far as the testimony, it's not clear on the record. There's no clear articulation by Judge Hart at the trial level as far as clearly striking and certainly not giving an additional instruction at the time. So I'd have to. I agree that the transcript is the transcript, and the exhibit itself was stricken. There was no additional instruction given, but it still you still have to look at, of course, the entirety of the evidence that was presented, and as we get into ineffective assistance of counsel, was counsel deficient overall? I mean, what is the standard here? And so obviously, was counsel's performance deficient in this case? Plenty of information in the transcripts about trial counsel's capabilities, his years of experience, his assessment. He did at least move to strike successfully, I might add, through argument that 40 needs to be struck. And just as my colleague here said there's some things you want to argue, some things you don't, I guess. But I didn't agree with the trial court's decision at that point as far as the rationale for it. But regardless, Exhibit 40 was struck. And that was after trial counsel aggressively defended his client and tried to get that information removed. He did so successfully, I'll point out. Obviously, the second prong of ineffective assistance is dealing with the reasonable probability that without these errors that might have infiltrated a jury trial, would the result have been different? And while I give deference to the Supreme Court and their decision and the opinion that they drafted, in which they did say there was overwhelming evidence in this case, and they did have this, I don't believe that on this 1507 motion that I think it would be extrapolating quite a bit to say what the Supreme Court did or didn't know and didn't have it accessible and certainly didn't have available to them with regard to looking at the decisions that the trial court made in total and looking at the evidence that was presented in total. You looked at the number of witnesses, they looked at the exhibits, looked at the outcome here. Would the result have been different in this case had Exhibit 40 or the testimony regarding it not been included as part of this trial? And again, I'd stress, and it's enumerated quite a bit in the brief that I filed as far as the amount of evidence or the weight of evidence that was significant. And I think that was acknowledged by Justice Beyer as well as the unanimous Supreme Court in their decision on the direct appeal. Was there an objective standard of reasonableness that trial counsel just overlooked? And I'll go on more to the second issue here, which is talking about the witnesses and their interviews. The witness with when you had the witness the testimony with regard to Hayes, and Hayes is the person that Mr. Pruitt bought the gun from. His testimony did infiltrate this trial, or at least statements attributed to Hayes were mentioned. Again, trial counsel objected, and the court found it was hearsay, instructed the jury to disregard, and we moved on. Hayes was not referred to again after that, after the court made their order. With regard to the coercion of the witness Perry, these things were litigated in pretrial matters. It was determined that the statements were not coerced. They were admitted. The appellant, I guess, would want to invert everything and say, no, trial counsel should have basically alleged that it was coerced or that there was something untoward with regard to those interviews done specifically with the witness Perry. And what I'd suggest to you is that would be just as improper because the court's already determined that it wasn't coerced, that those were free statements. And third, and in general, and with regard to all of these witnesses, whether they be Coe, Ballinger, or Perry, there was considerable amounts of cross-examination, questions about their interviews, questions about their varying stories. And in fact, even in closing arguments, not only did trial counsel for Mr. Pruitt, but I, as a representative of the state, even acknowledged that these witness stories were varied and they need to be looked into. They need to these questions that we've had throughout the trial needed to be looked into because there were multiple stories. That was acknowledged in the trial. And even noted by the Supreme Court in the direct appeal that these statements were needed to be looked at sharply by the jury, and the jury did so. And they found, compared with all the evidence that was submitted, not only in form of testimony but also the exhibits, the ballistics information, the identification of the gun. Which, by the way, this isn't just about somebody said he had a gun or very vague. We had multiple parties, including Mr. Ballinger, the witness, that said he saw Pruitt with the gun that night as he drove him to the trailer court. He instructed, in fact, had a colloquy with Mr. Pruitt about the fact that he shouldn't bring a gun to this fight. He saw Mr. Pruitt remove the gun with him as Mr. Pruitt exited the vehicle and took off into the night towards the trailer court. And then about 10 minutes later, Mr. Ballinger noted that he heard what he thought was a gunshot and was so scared that Mr. Pruitt had done something with that gun that he actually took off on foot, abandoning the vehicle at that location. There was extensive story told that by Mr. Ballinger with regard to the identification of this gun by having it in Pruitt's hand. Later, Perry says, this is, by the way, the witness Perry is Mr. Pruitt's roommate, and he described in testimony from the stand about the fact that Mr. Pruitt woke up the next morning, told him he needs to go do something for him, and that's to go ditch the gun. He instructs Mr. Perry to go get rid of it. Mr. Perry leads law enforcement to the river, to the exact spot where he ditched the gun into the river. That gun is located. Mr. Perry says, yep, that's the gun that I threw in the river that Mr. Pruitt told me to put or to get rid of, and clearly identifies this shotgun. So it's not weak evidence with regard to the identification of this gun. It's not coerced evidence, and it's not just this mystery gun that was somehow shown to people that everybody blindly agreed to.
But you would agree though that he did identify the gun after it had been described to him in detail by the police, and that's instead of before.
Yes, but he also identified the location of it, exactly where he threw it. It's exactly where law enforcement found the exact same gun. And yes, they described it, but they're also describing the gun that Mr. Perry already had told them he had thrown it into the river at that location, 50th and Haverhill Road in Butler County, and they had located the exact same gun. He said, yeah, I mean, yes. At that point, it's almost a de rigueur identification of that firearm, because he'd already notified law enforcement about every other detail of that firearm, other than saying, giving a full description of the actual firearm prior to. He said, I threw this gun right here. They went and found it. They pulled it out. They just said, this is the only gun we found at 50th and Haverhill in the riverbed. Is this the one that you had? And he said, yeah, that's it. Now, again, I reiterate, Your Honors, this is also a matter of cross-examination. This was adduced at trial. Went through this. The real question here is this ineffective assistance of counsel, because that's the umbrella under which all the arguments that appellant is making, which was that trial counsel was deficient throughout this entire process. And what I suggest is trial counsel exhaustively cross-examined these witnesses. They didn't do it exactly how the appellant says that they would have done it or feels that it was required. But you can go back and look at the trial transcripts, and you can see the cross-examination, the questions, the stories, the steps that were taken, the numbers of interviews that these witnesses faced. But most importantly, they were there. They actually testified and were subject not only to my direct, but also the cross-examination by defense counsel in total. The jury heard all of it. They listened to this evidence. And at least on direct appeal, the Supreme Court's already looked at this and said it was actually a considerable amount of evidence. I don't want to mistakenly read the evidence, but I will note that in appellant's brief, the last words of the statement that's been cited, we're talking about the fact that it says, in fact, the last sentence of that portion is, this makes the case very nearly a law school paradigm for premeditated murder by someone. And we have already referenced the strong evidence that the someone was the defendant. They're referring specifically to Mr. Pruitt, not an unknown assailant, not an unknown person, not an alternate individual, not anybody else other than Howard Pruitt themselves. I guess at this point, I'd still rely on the brief, and as we've submitted it, as far as the enumeration or the articulation of all the other evidence that we had against Mr. Pruitt, I think that's put forward in the writings, but certainly be available for any questions that the court might have.
I think we're good. So appellant, you have 3 minutes rebuttal.
2 quick points to address. First of all, the motion was to exclude their testimony, Perry and Ballinger. What counsel should have done, I mean, you're not relitigating that. What counsel should have done and needed to do to be effective is to make sure that the jury understood that the sequence of events of those interviews were as follows. Here is the gun. Here are the pictures of the gun. Here is where we found the gun. If, Mr. Perry, you threw it there at Howard's instruction, you won't go to jail. Oh, why, yes, I did. That's correct. I threw it there, and that was the gun. The jury didn't know that. The Supreme Court didn't know that. That's incredibly damning in terms of credibility. And when it turns on credibility, you got a problem. I'm not suggesting that he should relitigate coercion. I'm saying that he needs to let the jury know that, let the Supreme Court know that on review. That was the sequence of events, and that's very important. Next is a Supreme Court case that came out that's in our brief, State versus Balburney, I guess is how you say it. It's 2020. It was after Pruitt. Similar scenario where there's multiple witnesses saying somebody stabbed this individual, but there's a 911 call saying somebody else did it. And the line from this decision afterwards says, talking about how this is a credibility issue, there's a reasonable probability the jury would view these credibility issues in a different light had they heard that 911 call. Applied to this case, there's a reasonable probability the jury would have heard the credibility of Coe, Pruitt, and Ballinger differently had they known that their testimony came, this claim that Mr. Pruitt did these things came only after they were showed the gun, told what the police believed happened, and said, you won't be in trouble if you say what we just told you we think happened. They then say that, they then identify the gun. The ruling by Judge Hart did not exclude that type of cross-examination. In fact, effective assistance required it. The pretrial ruling by Judge Hart simply said that they can still testify. It was not coerced to the point where it must be suppressed and excluded. Prejudice is shown.
Thank you, counsel. We appreciate both of your arguments. We'll take the case under advisement and get you a decision in writing when we can.
Thank you.
Thank you.